The Pennsylvania real estate seller disclosure law, this is what you need to know as the seller. Disclose, disclose, disclose. And the reason being is because the exposure associated with the lawsuit after you close, if you don't disclose a material defect, is not only significant, it's also prolonged period of time. Pennsylvania has 2 consumer protection statutes that apply to this type of case and also common law. But the 2 statutes, the first is the Pennsylvania Real Estate Seller Disclosure Law in Title 68, and the second is the Pennsylvania Unfair Trade Practices and Consumer Protection Law, which is the Title 71. These statutes allow a buyer to sue the seller 2 years from the date of closing under the seller disclosure law, 6 years from the date of closing under the UTPCPL. With respect to the seller disclosure law, the damages associated with that you would be exposed to would be the cost to repair the property, or if repair is not possible, the diminution in market value of the property caused by the material defect that you did not disclose as the seller. With respect to the UTPCPL, the damages are not only the actual damages associated with the non-disclosure, but also the attorney's fees incurred in prosecuting such a case and trebling your actual damages, which fancy word for 3. So if the actual damages are only $5,000, they can treble those, so it can be $15,000 plus your attorney's fees. So they can really increase the level of your exposure on a monetary level. Plus, of course, it's a 6-year statute, so that's hanging over your head for quite some time. There are, however, of course, defenses that a seller has available to them. It's very important to consult a real estate attorney that practices in this area so they can apprise you of those defenses. For example, if there is a licensed professional that offers a report covering a certain topic. If the seller produces that report to the prospective buyer, then they can rely upon that report, and even if the report's wrong, that can serve as a legal defense to the seller. There's also a lot of exculpatory provisions that are built into the agreements of sale. In Pennsylvania, you'll find that most often, especially if real estate agents involved, they'll use what's called the PAR form, so the Pennsylvania Association of Realtors. That agreement contains multiple provisions that can be used in this case as a defense for the seller. There's a release provision which sellers wrongly think is the end of the day. There's a release provision which says that the buyer cannot sue them for any type of unknown problem that they find after the closing, such as a physical condition defect in the property. So sellers think that's in there, it's an as-is sale, I'm solid. That's not the case. So while the release provision looks fantastic to the seller when they're selling the house, please note that that is not going to circumvent any exposure to you if in fact you do make a statutory violation and or make a misrepresentation to the buyer.